Hello everyone, welcome back to another episode of the Darrell Brooks saga. Today we're gonna do the cross-examination of Detective Carpenter, which should be fun. I'm sure Darrell has a lot of questions for this guy. But first of all, thank you for subscribing. We are almost there. We are less than 40 subscribers to get to 1,000. We can get there. I know that you guys, if you guys like the content, if you guys want to see more videos come through and get notified when they come out, please subscribe. Give it a like. Give it a like to the video. That helps the channel a lot. And now let's get to the video.
Viewing of the vehicle that was recovered by the Waukesha Police Department. There were preliminary discussions when you were still represented by counsel, and the request is being made that the viewing of this vehicle take place tomorrow. Your response, if any?
First of all, I accept for value in return for value this paperwork.
Okay.
I guess I'm still confused as to why there needs to be a jury view.
I can have the state put their request on the record again. I'm responding to their request. So go ahead, Attorney Opper.
So the jury view is to get a look at the car, like the murder weapon, like the dangerous weapon that you used in the parade. So I think it's a good evidence to watch.
Brooks has been charged in every count with acting while armed with a dangerous weapon. We believe it's relevant and appropriate for the jury to view what we're alleging to be the dangerous weapon in this case, that is the 2010 Ford Escape.
Yeah.
It's essentially would be no different than bringing a firearm into the courtroom during a shooting case.
Yeah.
In terms of the time that's being requested, do you have any position on that?
Do I have to be present for this?
Sure.
I would like you to be, and yes, we're making arrangements for you to be there, sir.
Do I have to be present for it? And also, for the record, I don't consent to the name that's being referred to.
I'll use this opportunity, sir, to ask what name you prefer to be called, because we now have evidence in the record where you provided your name to, upon questioning. There was video from when you were taken into custody, and then, of course, Detective Carpenter has testified about that as well. Again, I try to refer to the parties by name because that is how I believe I demonstrate respect and decorum in this courtroom. And we've been given no other name, sir, by which to call you by. And I must, at that point, go back to what's on the criminal complaint, which is the initial charging document. That is what was filed in order to initiate the case.
Yeah.
With all due respect, the record should be corrected. I didn't put anything on the record that was...
Yes, you do. You did. One, you did it while you were being arrested. You say you were Darrell Brooks. Two, in the interview that we just saw, you said that your name was Darrell Brooks. Three, and this is recent, it happened like less than a week ago, and you can see it on my video. You decided that you wanted to be called the unknown individual. So he's lying again.
I didn't state that. I said there's evidence in the record.
Yeah.
Well, evidence, what you referred that evidence to me.
Yeah, you said it in the video.
So there's evidence in the record, but be that as it may, I'm just letting you know I'm going to keep referring to you sometimes as defendant, sometimes as sir, sometimes as Darrell Brooks, sometimes as Mr. Brooks. I understand you may still have an objection, but I've been given no other name from you by which to call you.
I follow, but there's still a lack of understanding. Are you referring to the name that was in all caps on all the filings?
Your name, what you are called.
Because every filing that I have,
I find the response to be kind of disingenuous.
Yeah.
So there was
this is, I believe, a tactic by you to
Yes.
create some type of confusion, which I don't believe there is any, about who you are and what name I need to refer to you as.
I never said you had to refer to me by any specific name. That's not what I'm saying. I'm saying that every filing that has ever been filed was in capital letters.
doesn't
That's
matter.
a fact. I have paperwork to prove that.
This is clearly where the tactic is. It's like she's asking you, the person that she's talking to. It doesn't matter the other files or whatever. She's just asking you what you want to be called. So
I don't recognize that name, nor do I know any individual by that name. That's all I'm stating.
Well, let's assume for a second that it's not in all caps. Do you recognize that?
No, I do not.
there you go.
Because
We have
there
our
were-
answer then. We're going to keep going, sir. We're a little bit off topic in terms of the request.
And that exactly that is because he will never win an appeal. Like the judges are gonna see this moment and they're gonna be like, nah, take him out. Put him out.
By the state. I'll give you one more opportunity to answer that. They've requested that whatever we're doing tomorrow morning, whether it be their case, whether it be if you are calling witnesses, that we pause about 11:45 in order for the jurors, the court, and the parties to be taken to that secure location for that jury view. Do you have any position as it relates to that?
Yeah, my position was when I answered, I said, do I have to be present?
I'm requiring you to be there, yes.
Yeah.
And what reason do I have to be present?
Unless you're willing to go through a colloquy with this court and intentionally waive your right to be there, because then I'm going to require you to be there.
And that's not explaining why I have to be there, though.
It doesn't need to be explained.
Because I'm requiring you to be there, sir.
And you just made that decision now?
All right. He's
Hold on.
not answering the question that I asked him. We will pause
I'm
at
trying to get
approximately
understanding, that's all.
11:45 tomorrow morning.
Don't I have rights, though, Your Honor?
You do.
All
You
right.
have the right to be
Then
there
with that,
and not to be there.
Ask another question.
Go ahead.
Scheduling, Your Honor. We still have not received anything from Mr. Brooks as to the date and time when he would like his witnesses ordered to appear. I don't see anything was e-filed.
Mr. Brooks, we need to know which particular witnesses on which day and whether it's AM or PM. Don't need to give me the order. We'll have them come in groupings, but it's not reasonable that they all come on the same date.
Yeah.
So you need to provide that to the DA.
How am I supposed to provide that to the DA?
You can
Write
write
it.
that down. Or
Yeah.
you can put it orally on the record right now. I asked you to bring it with this morning, and I didn't cover that this morning, so you were put on notice of that. But I'll give you until
I was put on notice of what?
If somebody needed to give notice to an employer and it can't be accommodated, then that may affect things for Mr. Brooks. But I think 24 hours notice is generally reasonable, and we will do our best. We can assure the court we will do our best to get them here, but I don't know if we'll be able to exactly accommodate the timing that he may or may not want.
all right. So, Mr. Brooks,
Objection
to
to
be
that, because when the subpoenas were served to them, I'm assuming that they would have let any employers or anything know that they
You don't
were
assume
expected
that.
to testify in a trial. I don't understand why it will become a problem at the last second.
Because it's
by
last
the
second.
start of court tomorrow, you need to bring with you, either in writing or be prepared to put it on the record orally, which witnesses you want. Use your best judgment on that.
Yeah, I don't know how I'm gonna come up with exacts on that.
I presume you're going to prepare some questions, and you might be able to kind of gauge how quickly that will go or not. If not, we'll do our best, but you've got
That's
to
your first mistake, Judge. He's not gonna be prepared with anything, even with his witnesses.
provide some definitiveness. It's not reasonable to just have these witnesses all come on one day.
Right.
I'm informed of what you're saying. I just feel like that same courtesy wasn't afforded to me by the prosecution. They didn't have to tell me exactly what witnesses was being called on what day and all this and that. Why is it not even
I am
even
requiring
playing
it,
field?
sir, because they are assisting you, because they graciously agreed to do that because you are representing yourself.
Yeah.
If you
So-
want them to be out of the loop on that, then I can just put it on your responsibility and your shoulders. But that is up to you.
Yeah. Like your
What do you
bill.
mean by put it on my shoulders?
You can contact them.
How am I supposed to do that?
You have access to a phone in the jail.
So I'm supposed to call everybody that I subpoenaed,
Yeah.
not knowing their information?
That is one way to do it, sir. Their information is in the police reports.
That is highly unreasonable. When one person that's on my witness list, I'm not even permitted to have contact
That
with.
would be
So
a
how-
good exception to that. So that's very astute of you to point that out, sir. That would be one exception. But other than that, in any event, sir, we're kind of a bit off track. We're going to get back on track, and you need to provide the information that's provided, that I've outlined here today.
I don't think that's fair, Your Honor.
Oh, your objection is noted, but it's my ruling.
The state didn't have to do that, but I have to do that.
Yeah, because
Sir, I remind you that
They're
you are
helping
nonetheless
you.
required to follow the rules of procedure, just as any attorney would have to if they were representing you. You've chosen to represent yourself. The state has graciously agreed to assist. They've served the subpoenas on your behalf. They didn't have to do that, but they did. They're simply asking for some basic courtesy so they can then relay that information to the witnesses you want to call in this trial.
I'm informed of that, Your Honor, but
All right, then let's move on.
that's
Yeah.
actually under the confrontation clause in the Sixth Amendment. I should be able to have the right to have witnesses subpoenaed.
yeah, and they were.
It shouldn't. Why is that?
Again,
being
we're getting a
overlooked?
little far afield here, sir. Subpoenas were provided to you. The record is very clear on that. We assisted you with that. I even reviewed them for completeness. And then the state assisted you with serving them. That is something they are not required to do, but they agreed to do in this case. So nothing about your Sixth Amendment has been violated in that regard.
Did I
You're
say
calling
violated or
these
did I say I'm
witnesses,
not?
So you need to understand that, sir.
I don't understand anything. And for the record,
All right.
I didn't bring up the word
let
violated.
us continue then. We're going to move on, Mr. Brooks. Let us
So-
continue with the
So we
questioning
gonna move on to
of...
subject matter jurisdiction that
No,
has
I'm
yet
not.
to be proven.
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not going to address that at all. That's not going to be proven for the record.
No.
Is that a judicial determination that you don't have to answer the question, Your Honor?
A tacit
Is
agreement.
that also a tactic agreement?
There we go.
The state would move Exhibit 82 into evidence at this time.
All right, you want to do that in front of the jury or just with me?
I wasn't sure if the defendant would have any objections that would need to be heard off the record or outside the presence of the jury.
Well, can you have them hold for a second? Do you have any objection to Exhibit 82?
Yeah, I got objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and
The
Detective
video
Stern.
of all your lies.
Your
It's
objection is to
relevant.
relevance? Your objection's noted, it's overruled, and I will receive Exhibit 82.
The court will let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that
Huh?
the true nature and cause has not been presented to me? That I don't know what
What?
the true nature and cause of the charges are?
What are you talking about? We were talking about the video getting in there. Why are you talking about the nature and stuff? That doesn't matter.
Your Honor, may I see a sworn affidavit of the nature and authority of the court?
No.
Or is that a judicial determination? You won't answer that as well.
Welcome back, ladies and gentlemen of the jury.
I like what she
The record
ignores him.
reflects that.
Record will reflect that Detective Carpenter is back on the witness stand following the break for the lunch hour. And Mr. Brooks, you may start your cross-examination.
I don't consent to being called that name, Your Honor.
Your objection's noted, it's overruled. Please ask your
Can't be
questions.
overruled.
It's overruled.
Detective Carpenter.
You don't know him. He's getting ready. He's pumping himself up.
Did you attend the parade that evening, November 21st of 2021?
Yes.
What time did you leave?
I don't recall the exact time.
And when you left, where did you go?
Our temporary police department.
Temporary. Explain what do you mean by temporary?
Not permanent?
So at the time of the incident, the building we are in currently, which was our main building, was under construction. So we were displaced.
What were you guys using for the temporary police station?
The city annex and city hall. We're in two different buildings.
Does any of those buildings consist of a room for interrogation?
There is at the annex.
And so when you initially interrogated the suspect, why was the annexed interrogation room not used?
Well, when I interrogated you, Mr. Brooks, the annex room was not used because the situation was very fluid. There was a lot of information being learned. We knew this was going to be drawn out. There is no municipal lockup facility at the annex, so it could not be utilized.
And so the police holding room in the hospital was more sufficient.
Yeah.
You asked to go up there for medical clearance.
Why would a hospital police room be more sufficient than the actual police station that you were utilizing at the time?
You requested medical clearance at the hospital.
So was there sufficient lockup at the police room in the hospital?
It's a police room.
We had areas in the hospital, so when you were being treated by the doctor, you could be handcuffed to a bed.
How come the suspect couldn't be handcuffed at the annex for the interrogation without having to be handcuffed to a specific bench or whatever you refer to it as?
Well,
I guess essentially what I'm asking is could the suspect still be properly detained while being interrogated at the annex versus the police holding room in the hospital?
so let me make sure I have this straight. Your question is about detainment. Do I have that right?
I think the question was very clear.
It
Detective.
wasn't. It's nonsense.
I can't answer it if I'm not going to get clarification.
Good.
And where was the suspect taken upon being detained?
You were taken, Mr. Brooks, upon the time you were arrested, down to the substation on Les Paul Parkway in Waukesha.
Do you recall what information was obtained at the substation?
Yes?
Do you recall what that was?
Yes?
Can you state for the jury and for the record what information you obtained at the substation?
Yes, sir. Basic biographical information. So I obtained your first name, Darrell Brooks, your last name being Brooks, your full middle name, I should say, being Edward. I learned that you were a junior, the date of birth, February 21st, 1982. Additional information obtained was your home address, which was you provided as 4014 North 19th Street in the city of Milwaukee. Phone number, your emergency contact, which you provided as Dawn Woods. Whether you were employed, going to school.
Kept mentioning that name, pretty slick.
What is your name?
Sure, disregard that last statement. Sir, please ask questions. You'll have an opportunity to testify later.
Oh, I got a lot of questions.
Ask them.
And at that point in the investigation, what did you initially know?
At that point, we knew that the red Ford Escape had driven through the parade route and that you'd been identified as a suspect.
And why was that information not provided at that time to the detainee?
Detainee.
The information at the time wasn't presented to you, Mr. Brooks, because, as I stated in my earlier testimony, it was very chaotic out at the scene. There was still a lot more that needed to be learned.
So is that standard procedure to not tell a person why they're being detained?
They told you.
Well, we didn't not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is that the same as...
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
Nice.
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So
Yeah.
with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
Again, that's misleading. They told you what you were detained for. You're just spinning it to make him look bad. And also, you guys know that I hate this. He has the two buttons button up. So here we go. I'm gonna go to the parentheses here. There are nevers, there are maybes, and there are always. If you're standing up with a suit and you have a two-button suit, you always button the top one and you never do the bottom one. If you have only one button, well, you button it. And if you have three buttons, you never button the lowest one. You always button the middle one, and you sometimes, depending on the occasion, button the top one. There you go.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
Yeah.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
So it'd be fair to say that it was not a fact as far as the information you learned to that point in the investigation.
Objection then.
Grounds.
Sustained is to the form of the question.
So at that point in the investigation, it wasn't a fact.
What?
Objection, same question.
Grounds.
Sustained is to the form of the question.
At that point in the investigation, the information you had at that time, you weren't sure about.
Right.
I guess which part?
All the information that you had up until that point.
Okay, about the prowling or parade, I don't understand which part of it you're talking about.
All the information that you've obtained at that point in the investigation, you weren't sure about. As you just said, you don't try to assume guilt or anything like that until you have all the facts. So at that time, at that point in the investigation, is it fair to say that the information that you had obtained so far, you were not sure about?
I wasn't sure if you were the driver initially, but it was believed you were involved.
And you knew that to be fact?
Yes, the information being provided was that you were involved.
So it'd be fair to say you knew that as a fact?
Well, hold on. I'm going to not allow him to answer that. This jury will determine the facts of this case. If you want to ask him his opinion, you do that at your discretion.
He said fact. He said facts.
You asked
said
the question,
fact.
sir. So
He brought it up first.
I'm going to strike the question from the record, and Mr. Brooks, you're directed to rephrase.
I will rephrase, but I do not consent to being called that name for the record. So why did you constantly tell the detainee that they were being detained for loitering and prowling if you in fact knew that there was another reason why they were being detained?
Objection asked and
Grounds.
answered.
Sustained. That's the form of the question.
What was the significance of the FBI being present?
The significance of the FBI presence was the early on concern that this was a terrorist style event.
And you said that this was a terrorist element. And what is the this? Can you explain what the this is?
What?
When you
Yes.
drove your vehicle through the parade and struck people.
Which at the time you stated you did not know is fact, correct?
Sure.
That was still being investigated, yes, but I know that's what occurred now.
Now versus then.
Yeah.
Initially, it was unknown if you drove,
That's what I
as
was
stated.
That was the question.
But the investigation showed that you were the driver of the vehicle.
And initially you didn't provide that information, correct?
He didn't know.
Correct.
He just said on the record when you asked him if he knew at that time, he said, no, I didn't know at that time. And he was like, then why didn't you tell me about it? Because he didn't know. What? Am I taking crazy pills here?
So do you know if the FBI continued their part of the investigation?
Eventually, the investigation was strictly run by our department.
And do you recall why that decision was made?
Why not?
My understanding is there wasn't a terrorism link.
You made reference to
Nice shoes.
car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
Were you told by other law enforcement?
I guess told what exactly?
That a car key was found?
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
At the time that
At
the
any time.
detainee was detained in the substation.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand.
I guess the clarity that you may be looking for is what was found and brought into the substation?
Okay. The Ford ignition key and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name, or debit card, credit and or debit cards with your name on them.
That you did not search and find yourself, right?
That's correct.
So it'd be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in,
No, I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
were you at the scene of the search?
He says no.
No.
So how do you know where they were found?
They told him.
Because they were turned over to Detective Stern as your property.
There's video about it.
How do you know where they were found, though, if you weren't at the scene?
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Can you strike that last answer from the record? I didn't refer to any house, grass.
You asked an open-ended question. His answer will stand. Your request is denied.
He was a
So it'd be
striking
fair to say
question.
that in the question I did not mention a house, grass, or a city? That'd be fair to say?
Sure. But you asked about it.
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Can you strike that
No.
last answer?
Request is denied.
On what grounds, Your Honor?
You asked about it.
You asked the question. He answered it. If you want to limit, ask leading questions and direct him.
Yeah, it's cross. You can lead.
That is your right.
You
During cross.
made reference to the house where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you are referring to?
What?
No.
Even though it'd be fair to say that you were not present.
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
That's what happened.
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
Sure.
I can't explain exactly what another's body's feeling, correct.
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
The video is transparent, my guy.
I think that depends on the circumstance. In this specific circumstance, you told me...
The last follow-up, if he wants it.
Okay.
You made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence, yes.
You would like the audio recording from the hospital.
Yes, Your Honor.
Do you want it started right at 4:25?
Yes, Your Honor.
I'll grab you.
I'll tell you.
Darrell?
Yes, sir.
Hey, Darrell. I'm Jeremy Wojciechowski. I'm the FBI.
FBI.
Yeah.
FBI?
I'm Mary. Yep.
They're just kind of helping out because we're so short-staffed tonight. So,
Thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
From hearing the audio on this Exhibit 81, do you recall saying that the FBI was present because you were short-staffed?
that is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
Do you recall being short-staffed at that time?
Yes. You drove to a parade.
Yes.
They were rushing to the
And
hospital.
Can you explain what the short-staffed mean as far as at that time, what would short-staffed mean?
That we were just very short on resources with what happened down at the parade route and the mass casualties and the amount of officers it took to secure that location, we were very short on people.
And
People were called in off duty.
You made reference to the short staff being the reason why the FBI was present.
Right.
Yes.
Is FBI usually present in the situation of short staffing?
No.
At some point, the detainee was moved to the Muskego Police Department, correct?
Yes, you were moved to the Muskego Police Department later in the evening.
And when did you learn that that would be a location that the detainee would be going to?
After the first interrogation attempt.
First interrogation attempt. How would you define attempt?
I read you your Miranda rights verbatim from the Waukesha Police Department Miranda statement form. And at that time you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point.
Right to silence.
Under the Fifth Amendment.
Yeah.
So acknowledging now the fact that the Fifth Amendment right was invoked not to speak, or as you say, the right to silence, why did you continue to record on your phone?
Why not?
So we are trained at our police department, when you do an interrogation, the recording is to be left on pretty much until you try to effect transport.
Even once a detainee has invoked their right to silence, you still continue to record? Is that a standard practice of your agency?
Yeah.
Yes, it is, for as long as they remain in the room.
And the reason why is, and correct me, you guys can correct me if I'm wrong, because if you invoke your Fifth Amendment right to silence, it's okay. You don't have to talk anymore. But after that, if you talk, if you break the right to silence, then it's fair game again. You are talking. And I'm sure he was singing like a bird.
So when did you start recording?
Prior to you entering the room.
So you started recording before the detainee entered the room, and you said you keep the recording on until they leave the room. So would it be fair to say that there should only be recording while the detainee is in the room?
No?
No.
And you did say for the record that that's standard procedure in your agency.
In regards to the interview rooms at our normal police department, which wasn't available at that time, yes.
Would it be fair to say that you were not at the normal police department?
Yes, however, with the audio, I was still trying to make sure I followed the policy to the best of my ability.
Can you show proof of that policy?
I don't have it.
So it'd be fair to say that there's no way to determine if that truly is policy if it can't be proven.
Objection, argument.
Grounds.
Sustained. As to the form of the question, it's argumentative.
How can that policy be proven?
Objection.
Grounds.
Sustained. On relevance grounds.
Do you know where that procedure is located in your agency rules?
Objection,
Grounds.
relevance.
Sustained.
Grounds for the sustain, Your Honor?
Relevance grounds.
Yeah, what does this have to do with your case?
Relevance. Not relevant. Next question.
It's not relevant?
It's not. Don't laugh.
No, keep going. We can take it up later outside the presence of the jury at our afternoon break, but for now, keep going.
You stated to being present during the booking process into the Muskego Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal, considering that you said there was a lockup. I forgot how you referred to it, but basically like a room that the detainee could be secured.
Well, you had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and refresh yourself.
And what bearing would that have on interrogation?
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested. So we wanted to give you the opportunity to do that.
In your opinion, how would that have affected interrogation?
I'm going to excuse the jury right now. So if our jury, we could stand for the jury so I can take up a legal issue, please. So I'm going to take up two issues right now. One is when I paused earlier and told Mr. Brooks I would allow him to, it was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined. But I'll hear you out on that.
The policies. That's relevant because I think it should be stated for the record why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point, interrogation is supposed to stop completely.
Well, I understand what you're saying from a legal perspective, but why do you believe having the specific policy and him testify about the specific policy is relevant to his testimony?
Well, I believe that if that's in fact policy, it should be proven. It should be proven that that's a fact, that is a real policy. For all we know, he could just be saying that it's a policy. And at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now, you assume facts that are not in evidence.
If he's saying that this is a policy of his agency, he should be able to prove that that's policy.
How?
Because at that point, if there's no way to know that that is the correct procedure that they use every time, then why?
Again, making a lot of generalizations that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery, and frankly, his conduct isn't on trial. We're not here about a police misconduct trial. I'm not saying that some of this information might not be relevant to his credibility, things of that nature, but you have to, again, you're the proponent of this. Why do you believe those policies relate to an issue of fact in this case or otherwise go to your defense?
I believe that is relevant because it can show that at the very minimum that first interrogation and anything related to it should not be admissible as evidence.
I've already ruled on the admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no requirement that the state or this witness has to prove those policies. You are representing yourself. Hold on, let me finish. You're representing yourself. I'm not aware of any subpoena that required him to bring those policies with. So that would have been on you if you felt it important to cross-examine him on those policies to require that. I'm not aware of that. Have you done that?
obviously it was going to come up.
No.
Did you issue a
It was-
subpoena ducus
it's not
tecum to
obvious.
this witness to bring with any of his policies
How
related
can
to
I do that
interrogation?
myself, Your Honor? How can I do that
With a subpoena.
from a jail cell?
You were given all of those blank subpoena copies, sir, and you could have filled that out in a way for this witness to require. You didn't do that,
So who would have served him?
The
the
state.
state would have. They served your other subpoenas, and they're so. I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
It's relevant to the case because why would he be recording before people are even in the room and then after?
It's like a camera.
Well, that's
like-
argumentative, sir.
Like a camera that is in the room. It's always recording. So it's recording before you enter and after you leave. They don't have to like click stop and click renew. I don't know what he's saying.
So
Once
that's
the
not a
Fifth
legal
Amendment-
basis.
Once the Fifth Amendment is invoked, interrogation is supposed to stop. Period. There's supposed to be no more recording, no
Nah.
more questions asked.
Nah.
That's
not how
should be
it
the
works.
end of the whole interrogation.
These are legal issues that you're trying to raise before the jury. I've already dealt with the admissibility, so you've not provided a legal basis to further question this officer about policies related to the interrogation and the recording.
Do you recall making a statement that we all know how women can be? They're crazy.
I do.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony. Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just wanted you to feel comfortable talking to me as a person. I felt we had rapport. I felt I could tell the night before you were comfortable speaking to me. And it was just a continuation of that.
Why did you feel that would have been necessary to build a rapport that you stated that you already felt that you had?
It worked. You talked.
And I was just continuing to go along those lines. It wasn't anything other than that, other than to just communicate with you on a I guess, stiff level, relaxed level.
And do you feel, would it be fair to say that other comments could have been used to keep the detainee at ease?
Why does it matter?
Objection, vague.
Grounds.
Sustained as to the form of the question.
Was there any other conversational tools you could have used to keep the detainee at ease?
Objection, same.
Grounds.
Overruled. The witness may answer.
Perhaps, maybe.
Would it be fair to say that you felt that at that time, the conversational tool that you used would be more appropriate for the situation?
Right?
I don't know that I was really thinking about appropriateness. Like I said, I was just conversing you on a normal person-to-person level was my intention at the time.
So it would be fair to say that you assumed that would put the detainee more at ease by
It
starting
worked.
a conversation along those lines?
That's not anything that I did just specifically for you, Mr. Brooks. I always want people to be as relaxed as they can be. I want them to feel comfortable to talk to me if they are willing. It doesn't change the fact that ultimately I have to read Miranda.
Speaking of Miranda, do you recall reading the Miranda rights in the second interrogation?
Yes, I do.
Do you recall how long into the interrogation before you read the Miranda rights?
Objection.
Grounds.
Objection, misstatement,
Grounds.
and mischaracterization of the evidence.
Grounds.
Well, sustained as to the form of the question.
Do you recall when in the second interrogation you read the Miranda rights?
Your Honor, I am going to object again to the form of the question.
Grounds.
The interrogation began. The court made a finding as to when the interrogation began prior.
I'm going to sustain the objection as to the form of the question. It calls for a legal conclusion. Next question.
Did you immediately start the second interrogation with the reading of Miranda rights?
No, that is not the first thing I stated to you. First, I explained to you what I was wishing to talk to you about.
Yeah.
And do you recall how long you were in that explanation phase of the interrogation?
Maybe around 15 minutes, 16 minutes.
So it'd be fair to say that you didn't read the Miranda rights till somewhere after already interrogating the detainee for 15 minutes at least.
Objection.
Grounds.
Misstatement.
Sustained.
Had you spoken with Ms. Patterson about the alleged domestic allegations?
I did not.
So it'd be fair to say that you, at that time, didn't know if they were true or not.
It's an
No,
allegation.
that wouldn't be fair to say.
And why would that not be fair to say?
Well, hold on. It's for this jury to determine the facts of this case, including the domestic allegations.
Is it fair to say that someone who is being detained would perceive that as being misleading when there's two different reasons why they're being detained that was told to them?
Objection. Speculation. This witness cannot know what is in someone else's mind.
Calls for speculation.
At any point in the interrogations, did you knowingly lie about the information that you had?
There was information I withheld from you, yes.
So it'd be fair to say that you lied.
Objection. Mischaracterizes this officer's answer.
It's argumentative, sustained as to the form of the question.
Just for the record, there is a point in there where you
Sustained
Stated
as to
that
the
he
form of
lied.
the question.
why did you continue to withhold information repeatedly?
Interrogation doesn't truly begin until I'm asking you incriminating questions potentially after you've agreed to waive your rights and speak, something you didn't do on the first day. On the second one, quite honestly, it goes back to what I've stated in my earlier testimony. I wanted to make sure the information I was getting from you was truthful. I wanted to make sure that I didn't lead you down a path of potential lies. And third, quite frankly, Mr. Brooks, I didn't believe if I gave you the information you were going to tell me anything.
You made reference to the first interrogation saying that there was no waiver of that interrogation?
Objection.
I'm referring to what he just said at the beginning of the answer.
I'm going to sustain the objection. Next question.
Grounds for the sustain?
Substain.
Next question.
Grounds for the sustain, Your Honor?
Next question.
Next question.
So I can't get no grounds. Okay.
Okay.
So you made reference to not being sure if you wasn't sure if you were going to get the information you were seeking?
Correct.
And is that what led you to lie about the information you knew?
Objection. Mischaracterizes the testimony.
Grounds.
It's argumentative. Sustained.
Did that lead you to not be forthright about the information you knew?
Objection. Argumentative.
Sustained as to the form of the question. His words were that he withheld. You may.
That led you to withhold information that you had obtained?
Well, again, as I've stated in prior testimony, strong part of the reason I withheld information is I wanted to gauge how honest and truthful you would be. I think it's important to note you lied to me, and this was proven by evidence, about your mother owning a vehicle. You lied about coming out here in a tan, possible Kia. So there were lies that were told at this point. You lied about being body slammed by officers.
In reference to the second interrogation, in reference to finding the phone, did you ever find the phone of the detainee?
You asked me if I personally did?
Yes.
I didn't, no.
Do you recall where the phone was recovered?
In your vehicle.
When you say your vehicle, who are you referring to?
Your mother's red Ford Escape that you were driving that day.
So it'd be fair to say it wasn't my vehicle, as you
Semantics, Mr. Semantics.
grounds.
Sustained as to the form of the question.
And there was a point in the second interrogation when you were attempting to show the detainee a video, almost as if you was forcing it in his face.
Right?
What were you attempting to show the detainee?
What you did.
I was attempting to show you a video of when you drove your vehicle through the parade route.
Any reason why you were being so forceful in trying to do that?
Well, I felt it was very important for you to see the damage that was caused from the incident. And Detective Stern made the statement as well. You were asking for more information, so we attempted to show you more information.
Yeah.
The night of the arrest. When did you arrive on scene to Elizabeth Street?
Shortly after you had been taken into custody.
When you arrived, what did you see?
Can't recall exactly. I believe you were already in the back seat of a squad car.
So at that time, suspect was already detained.
He said that.
You were detained.
Suspect
You.
already
Suspect
detained.
is you, Darrell Brooks.
Can you strike that last comment?
No.
That was his response. He will stand. All right. Thank you. Please have a seat.
Do you recall Mr. Brooks' questioning of you with regard to the recording
Objection.
made by your cell phone at Waukesha Memorial Hospital during the first meeting with...
Let her finish the answer.
Objection, I don't consent to being called that name.
Noted, overruled. The witness may answer.
Yes, I recall.
Are you familiar with the term excited utterance?
Yes, I
Objection,
am.
leading.
Oh, overruled. The witness may answer.
Sorry.
What is that?
It's when an individual, whether it be Mr. Brooks or any individual, begins making statements on their own accord and not response to a question. Typically, an utterance may reference why they're in custody in the situation that you were either questioning them about or preparing to question them about.
Is it important to capture those types of utterances on tape or recording?
Objection, speculative.
Overruled. The witness may answer.
Yes, it is.
Would that be a reason to continue recording after an interview's been ended?
Objection, answered that already.
Overruled. The witness may answer. It's redirect.
Yes, it would.
Did the defendant ever tell you that there was anyone in that car other than him driving it and possibly Erica Patterson?
Objection, leading the witness.
Overruled. The witness may answer.
No, he did not.
And finally, you've been a law enforcement officer in Waukesha County for approximately 18 years, is that correct?
Yes.
Who makes the charging decision when deciding what charges get issued in a criminal case?
Objection leading.
Overruled. The witness may answer.
The prosecuting attorney at the Waukesha County District Attorney's Office.
You don't decide on the charges?
No.
Objection.
We can forward what we believe is appropriate, but we don't ultimately make the decision to charge.
So when Mr. Brooks asked you, what am I being charged with? Did you have any ability to tell him that?
Objection. I don't consent to being called that name.
Noted. Overruled. You may answer the question.
No, ma'am. Not with 100% certainty, no.
Nothing further, thank you.
All right. Thank you. All right. Thank you, everyone. We are in recess. We'll see everyone at 8:30 tomorrow morning.
All right, that's gonna be it for day 9. We're gonna come back tomorrow with day 10. And it's been good. It's been great. I've been having a blast making those videos for you. Sometimes they're hard, sometimes they're funny, sometimes we have everything in this trial. So come back tomorrow. I'll see you guys then. Have a great day. Give it a like if you made it this far. I'll see you guys tomorrow.